Tonight, we begin with a legal confrontation that senior constitutional law experts have called unprecedented, possibly the most devastating judicial action against a sitting president's immediate family member we've seen in the entire history of the American Republic. The federal court moved on Ivanka Trump, not with a subpoena, with marshals, not with a negotiation window, with a deadline measured in hours, not with a warning, with an order that left no room for appeal. What the presiding federal judge did this week crossed a line that Trump's entire legal apparatus had guaranteed would hold. And when that line shattered, when the order came down and the marshals received their directive, the Trump family did not unite behind Ivanka. They did not rally. Melania Trump, when asked privately whether she would make a public statement of support for her stepdaughter, delivered a 3-word response that multiple sources inside Mar-a-Lago describe as the moment the Trump family fractured beyond repair. 3 words, that's all it took. Imagine this scene. It's 6:47 a.m. on a Friday morning in Palm Beach, Florida. Inside the private residence wing of Mar-a-Lago, Ivanka Trump sits motionless on a cream-colored sofa, surrounded by her personal attorney, 2 criminal defense specialists retained just 72 hours earlier, and the soft blue glow of a muted television cycling through coverage she cannot bring herself to watch. The room smells of untouched breakfast. Through the arched windows, the Atlantic is calm, but inside this room, nothing is calm. Ivanka's phone has been buzzing since 4 a.m. when the court filing became public. Present in the room and connected via encrypted call are the people trying to prevent what now seems inevitable. Abby Lowell, Ivanka's lead personal attorney, the veteran Washington lawyer who has navigated political legal crises for decades. Alina Habba, Trump family legal spokesperson, already drafting statements that would need to be rewritten before noon, a senior partner from a white shoe Manhattan firm, retained specifically because the criminal exposure had expanded beyond what Lowell's team could cover alone. These are the lawyers who were supposed to keep Ivanka out of a courtroom, who assured the family that cooperation would satisfy the federal inquiry, who promised that the document production would end the investigation, not accelerate it. Ivanka is reviewing the judge's order line by line, designed to compel her physical appearance, to prohibit further delay through procedural motions, and to authorize the U.S. Marshals Service to enforce compliance if she failed to appear. The attorneys listen. They take notes. They begin drafting emergency motions. And then, one by one, they set their pens down. Not because they gave up, not because they ran out of arguments. Every single emergency avenue, every stay motion, every jurisdictional challenge, every procedural objection had already been anticipated and preemptively blocked by the judge's order. And Ivanka, her hands perfectly still in her lap, as her attorneys exchange glances they think she doesn't notice, understands that the legal architecture her family spent millions constructing has just been dismantled in a single judicial stroke. Think about that. For weeks now, there had been signals, not from official DOJ communications, not from formal court dockets, just whispered conversations between defense attorneys, that the federal investigation had shifted from documentary review to something far more aggressive. The investigation has been methodical, yes, but it has been accelerating in its methodology. The subpoenas have followed a certain rhythm, a pattern, almost a tightening spiral. But what set off alarm bells inside Mar-a-Lago this month was that the spiral contracted suddenly and without warning. White-collar defense attorneys who monitor federal investigations know the indicators. The shift from document requests to witness testimony demands. The quiet impaneling of a second grand jury in a different jurisdiction. The sudden silence from prosecutors who had previously been communicating regularly with defense counsel. The abrupt withdrawal of cooperation credit language from government filings. All of that happened within a single 10-day window. And whenever federal prosecutors go silent, whenever the regular communication between government and defense counsel dries up, it means the investigation has moved beyond negotiation into enforcement mode. The legal strategy that worked for months, because Ivanka's team cooperated voluntarily, because they produced documents on schedule, and because the judge had shown patience with procedural timelines, has just been abandoned by the court. The judge concluded that key documents were withheld. The judge determined that testimony timelines were deliberately extended. The judge found evidence that electronic records had been altered after preservation orders were issued. When a federal judge concludes that cooperation was performative, that delay was strategic, and likely that evidence was tampered with, that's when judicial patience breaks down. That's when the marshals get called. Let me be very specific about what happened this week and why constitutional law experts immediately recognized this as a Category 5 legal crisis based on the judge's order and the unprecedented enforcement mechanism attached to it. The federal judge issued an order involving mandatory physical appearance within 48 hours, a contempt finding with civil penalties accumulating at $50,000 per day, and U.S. Marshal Enforcement Authority, designed to eliminate further procedural delay, to demonstrate that no defendant is above judicial compulsion, and to send an unmistakable signal that the investigation was entering its terminal phase. The order required physical appearance at a federal facility that Ivanka's team had spent months trying to avoid through remote testimony proposals, production of electronic devices, including personal phones that defense attorneys argued were protected by executive privilege claims. The court had already rejected testimony under oath on specific financial transactions that prosecutors believe constitute the core of potential fraud charges. Waiver of certain Fifth Amendment objections on topics the court ruled were already covered by prior voluntary statements. Abby Lowell, who normally demonstrates unflappable confidence in court proceedings, stated directly that the order was the most aggressive judicial enforcement action he had seen directed at a political family member in his entire career, that the 48-hour window was designed to prevent appellate intervention, that the contempt penalties were structured to be financially devastating even by Trump family standards, and that the marshal enforcement provision meant Ivanka could be physically compelled to appear if she chose to defy the order. When Trump's broader legal team attempted to intervene, dismissing the order as judicial overreach and suggesting that the judge harbored political bias, the court responded in language deliberately chosen to establish an unassailable record, but making clear that further obstruction would trigger criminal contempt proceedings. This court has extended extraordinary patience. That patience is exhausted. Compliance is no longer optional. Other legal observers supported the judge's position in terms that became progressively more alarming as the legal community absorbed the implications. Harvard law professor Lawrence Tribe called it a textbook escalation that signals imminent criminal referral. Former federal prosecutor Andrew Weissman noted the Marshall provision was reserved for defendants the court believes will flee or defy. The American Bar Association issued a rare statement acknowledging the order's extraordinary but legally justified scope. Multiple former judges confirmed privately that the enforcement language tracked patterns used before major indictments. Court observers confirmed the details through direct review of unsealed portions of the docket and through sources within the clerk's office. Within 6 hours of the order's issuance, emergency legal briefings were being delivered to Trump's personal attorneys, to Republican congressional leadership, and to Ivanka's husband, Jared Kushner's separate legal team. The consensus assessment was stark and unanimous. The court has signaled that voluntary resolution is no longer available. This is now an enforcement action, and the next phase will likely involve criminal proceedings. One senior Republican legal advisor speaking on background characterized it as the moment the family's legal firewall collapsed. Because the judge didn't just order compliance, the judge eliminated every mechanism the family had used to delay for over a year. Think about that. Legal analysts across the political spectrum monitored a federal court issuing martial enforcement authority against a former president's daughter, an action that constitutional scholars immediately assessed as historically unprecedented because no court had ever authorized physical enforcement against an immediate family member of a sitting or former president. The Trump family's legal strategy has always depended on one assumption, that no judge would dare authorize physical enforcement against a Trump. And that assumption just died. For over a year, delay was maintained because courts typically grant political families extended courtesy, because appeals processes create natural buffers, and because judges fear the political consequences of aggressive enforcement against high-profile defendants. That deference has just been obliterated. The federal judiciary has concluded that courtesy was exploited, that cooperation was performative, that delay was strategic evidence destruction, and that further patience would constitute judicial complicity. And most devastatingly, they've recognized that the Trump legal strategy of infinite delay only works if judges are afraid to act. And this judge is not afraid. When the judiciary concludes that restraint means enabling obstruction while enforcement means fulfilling their constitutional oath, that's when the legal ground shifts permanently. That's when families that believed themselves untouchable discover they are not. The response from within Mar-a-Lago tonight was not a coordinated legal counteroffensive. It was not a unified family statement of support. It was not a strategic communications rollout. It was silence, fractured, telling, devastating silence. Source after source within Trump's inner circle described the family dynamic as fragmented, blame-saturated, and perhaps most significantly, divided between those who want Ivanka to comply immediately and those who want her to defy the order and force a constitutional crisis. But family unity as a legal strategy only works if every member stands together publicly and unequivocally. The Trump family did not. In fact, the internal response this week was among the most fractured we've seen from any political dynasty in modern American history. Here's what we know. Within 12 hours of the judge's order, 3 separate fault lines emerged inside Mar-a-Lago. Jared Kushner retained independent counsel, a move that defense attorneys universally interpret as legal separation from his wife's exposure. Donald Trump Jr. publicly posted supportive statements, but privately told associates he warned Ivanka months ago to cooperate fully. Eric Trump's team began quietly distancing from any financial transactions that overlapped with Ivanka's portfolio. These weren't routine precautions. These were legal survival maneuvers, defensive postures that family members only adopt when they believe the investigation has reached the indictment phase. But it was Melania's response that shattered whatever remained of the family's united front. Sources confirmed that a senior Trump advisor directly asked Melania whether she would issue a statement of support for Ivanka, even a brief, carefully worded expression of family solidarity. Melania's response was 3 words. She looked at the advisor, she paused, and she said, "She's not mine." 3 words that reverberated through every room in Mar-a-Lago within the hour. They hit the family's legal confidence. They hit the public narrative of Trump family unity. They hit Ivanka personally because the woman married to her father had just publicly disclaimed her. In other words, Melania targeted the foundation of the family's legal strategy, the unified front that would have made aggressive prosecution politically costly. This is what made the situation so catastrophically different from previous Trump legal battles. Ivanka's legal crisis wasn't just a courtroom problem. It was an existential test of family loyalty. It represented the kind of internal fracture that could accelerate every pending investigation if left unaddressed. And Melania, understanding the weight of the moment fully, responded with calculated distance, not accidentally, not carelessly, but deliberately. She didn't misspeak. She didn't walk it back. She drew a line. She chose her side. And here's where the story becomes even more psychologically devastating. Legal analysts now believe that the federal judge's aggressive order was designed to test the structural integrity of the Trump family's legal solidarity after months of visible tension between family factions. The court wanted to see whether the family would unite behind Ivanka, whether Jared would subsume his own legal exposure to support his wife, whether Donald Trump himself would risk personal legal capital to shield his daughter. But instead, the opposite happened. The family didn't consolidate. They fragmented so rapidly, so visibly, that even the prosecutors were forced to recalculate the speed at which cooperation offers might now be accepted. You don't fracture the Trump family easily. But this week, one federal judge did. The psychological impact on Donald Trump personally represents the most significant challenge to his self-constructed mythology of family invincibility. Trump built his entire public identity around being a patriarch whose family was unbreakable, whose children were untouchable, and whose dynasty would endure any legal assault. Trump's entire political narrative depends on appearing to be a man whose family stands behind him absolutely. Melania's 3-word response directly eviscerates that narrative. Trump cannot acknowledge the fracture because that would confirm his family is disintegrating under legal pressure. But Trump also cannot pretend it didn't happen because every political reporter in Washington has now confirmed what Melania said. Trump is trapped between admitting his own wife has abandoned his daughter and pretending that the most consequential family rupture in modern political history simply didn't occur. That psychological bind, combined with the judge's enforcement order and the cascading legal separation of family members, creates conditions where Trump's decision-making might become increasingly erratic and self-destructive. Former White House officials speaking with CNN under condition of anonymity described Trump's current emotional state as cornered fury, a signal that the combination of legal pressure and family fracture has pushed him into territory where calculated strategy gives way to reactive impulse. But the federal court proved this week that it remains both institutionally committed and operationally aggressive. The judge's order was not only legally comprehensive, it was structured so precisely that every defensive avenue was preemptively closed before defense counsel could exploit it. That precision matters because it shows the judiciary wasn't reacting to the Trumps. It shows that the federal court is not intimidated by political power. They are executing a methodical legal process that was built to withstand exactly the kind of pressure a Trump family brings. Melania's public dissociation from Ivanka creates cascading effects that undermine the Trump legal architecture across multiple dimensions. First, it establishes that the Trump family is no longer a unified legal entity, meaning prosecutors can now approach family members individually with cooperation offers tailored to exploit the fractures. Second, it signals to Jared Kushner's legal team that spousal loyalty cannot be assumed, accelerating his own legal separation strategy and potentially opening new cooperation channels. Third, it creates a situation where Donald Trump must choose between defending his daughter and maintaining his relationship with his wife, a personal dilemma with direct legal consequences. Fourth, it sends an unmistakable message to Republican allies and to potential witnesses that the family's united front has collapsed, reducing the political cost of cooperating with prosecutors. And fifth, it inevitably accelerates the investigation's timeline because prosecutors now have evidence that internal family cohesion, the primary obstacle to cooperation, no longer exists. Now we need to talk about historical parallels because understanding how political family fractures have unfolded before illuminates why legal historians see this moment as potentially decisive for the Trump dynasty's survival. The most relevant parallel is the Nixon family during Watergate, when family members increasingly distanced themselves from the president's legal strategy as the investigation tightened. Nixon's family witnessed the legal walls closing in, the subpoenas escalating, the allies defecting, and the institutional support evaporating week by week. Those family members eventually counseled resignation, and because the legal exposure was becoming personal, because continued defiance meant potential prosecution of family members, and because institutional loyalty could not survive the weight of evidence. That fracture didn't happen through a single dramatic confrontation, but through a gradual erosion of confidence where each family member privately concluded that the patriarch's strategy was destroying everyone around him. The result was a resignation that ended a presidency and a family's political dynasty within a single generation. Another parallel is the Gambino crime family's dissolution in the 1990s, when family members increasingly cooperated with federal prosecutors because maintaining the code of silence meant personal imprisonment. John Gotti demanded absolute family loyalty. He enforced it through intimidation and reward. Many family members nominally maintained solidarity while actually negotiating immunity deals with the very prosecutors Gotti was fighting. The result wasn't a dramatic public betrayal, but a quiet cascade of cooperation where each defection made the next one easier and more likely. The Trump family is approaching a similar inflection point where the cost of loyalty exceeds the cost of cooperation for individual members. The visible collapse hasn't occurred yet, but the conditions that precede such collapses are manifestly present and accelerating with every court order and every three-word response. What makes this moment so extraordinary and so perilous for the Trumps is that the judge's order happened at a time when Donald Trump is under maximum simultaneous pressure. Congressional investigators want testimony and documents Trump has blocked for years. State prosecutors in New York and Georgia want to advance cases that federal drama has overshadowed. Republican primary challengers want evidence of legal vulnerability they can exploit, and Trump's own donor base wants assurance that legal costs won't consume campaign resources indefinitely. Trump is managing these demands while simultaneously facing the reality that his own family is fracturing under the legal weight. And when patriarchs in that position make sudden aggressive moves, they're not doing it from confidence. They're doing it from desperation. They're doing it from the recognition that the structure is failing. The strategic implications for federal prosecutors are profound and create both opportunities and risks that the DOJ is carefully calibrating. The opportunity is that family fracture opens cooperation channels that were previously sealed by solidarity. Prosecutors have already demonstrated the capability to leverage internal divisions, to offer targeted immunity, to turn family members into government witnesses. If the fragmentation accelerates, as legal analysts universally suggest is likely, if Kushner's legal separation continues, if Melania's distance hardens into formal non-cooperation, if the siblings' protective maneuvers become full legal separations, prosecutors might achieve cooperation breakthroughs that would be impossible under conditions of family unity. The risk is equally significant. A cornered Trump might attempt to use presidential pardon power preemptively in ways that trigger constitutional crisis. Desperate legal maneuvers could further obstruct investigations and extend timelines. Public sympathy for family persecution narratives could complicate jury pools. The Department of Justice is calibrating its approach to maximize cooperation incentives while remaining prepared for scenarios ranging from negotiated resolution to full-scale family prosecution. Think about what this means for the American legal system and understand why constitutional scholars who monitor these dynamics closely believe Melania's 3 words might represent the crack that brings down the entire structure. The question facing federal prosecutors is not whether the Trump family's legal solidarity has broken, which seems indisputable from multiple sources inside Mar-a-Lago, but how to leverage that fracture into actionable cooperation while managing the political firestorm that will follow. Legal strategists who characterize Melania's response as the end of the unified defense understand that the fracture creates extraordinary prosecutorial opportunities, but also dangers if the investigation is perceived as targeting a family rather than pursuing justice. The opportunity is clear. Individual family members are now calculating personal legal survival independently of the patriarch's strategy. The danger is equally clear. Overreach could generate public sympathy and political backlash that undermines the prosecution's legitimacy. Prosecutors are intensifying preparation for scenarios ranging from negotiated cooperation agreements with peripheral family members to full contempt proceedings against Ivanka to expanded indictment targets that include financial transactions involving Jared Kushner. Remember, Trump thought the family would hold together under any pressure. He thought Melania would stand publicly beside every family member without exception. He thought no judge would dare send marshals for his daughter, but tonight marshals have their orders. Melania has drawn her line, and the family that branded itself as unbreakable has just broken. Now let me bring this full circle to where we started tonight, to that moment at 6:47 a.m. in the private wing of Mar-a-Lago when Ivanka Trump sat motionless on a cream-colored sofa and understood that the legal walls her family built were not walls at all. What that moment represents is not just one family member's legal crisis, but the fundamental collapse of the mythology that the Trump family was beyond the reach of American law. The moment when the comfortable fiction of dynastic invincibility collided with a federal judge's order and a stepmother's 3 devastating words. Think about what it means that a federal court authorized U.S. Marshals to enforce compliance against a former president's daughter. Think about what it means that the family's response was not unity, but fragmentation. Think about what it means that Melania Trump, the woman who stood beside Donald Trump through every scandal, every investigation, every crisis, chose this moment to say, "She's not mine." That's not recoverable. That's a structural collapse where every attempt to repair the damage reveals new fractures and where the trajectory points inexorably toward a family whose legal strategy was always built on a foundation that never actually existed: loyalty. And here's the profound truth about political dynasties. They often appear invincible, but collapse results from accumulated betrayals and resentments that observers didn't fully appreciate until one moment made denial impossible. The Nixon family seemed solid until the resignation conversations. The Kennedy political machine appeared unshakable until internal rivalries consumed it. These collapses surprised outside observers because the internal erosion of trust remained largely invisible until a single crack made the whole structure uninhabitable. The Trump family is experiencing that same internal erosion. Now we're watching it happen in real time. The visible dissolution hasn't fully occurred yet, but the conditions that precede it are manifestly present and accelerating with every court order, every retained attorney, and every three-word response. This is where moral clarity meets legal reality. No family is above the law. No patriarch can demand loyalty that the law itself cannot compel. This fracture is the Trump family's own creation, not the judiciary's. And that fracture creates the possibility, for the first time, that justice might be pursued through the very cracks the family's own dysfunction has opened. Tonight, one thing is clear. The judge's order stands and the Marshals have their directive. The family that presented itself as unbreakable has shattered from within, and 3 words from Melania Trump have done what years of investigation could not. They've ended the illusion of unity. And tonight, for the first time in this entire legal saga, it is Mar-a-Lago, not the federal courthouse, that appears to be in crisis. The residence wing is quiet tonight, too quiet. And when Mar-a-Lago is this quiet, it means the family is not resting. They are retaining separate attorneys and calculating individual survival. Because tonight, the Trump family learned 3 things they cannot unlearn. That federal judges will send marshals for a Trump. That family loyalty has limits that a 3-word sentence can reveal. And that the dynasty they believed was invincible was always only as strong as the weakest bond holding it together. And that bond just snapped. This story is far from over. We will be here watching every detail as the next phase unfolds.